Mr. Chair, honorable senators, thank you for the privilege to appear here today. I'm the founder and coordinator of Air Passenger Rights, an independent and non-profit network of volunteers devoted to empowering travelers through education, advocacy, investigation, and litigation. We bring a unique perspective to the committee because we accept no government or business funding, and we have no business interest in the bill. We represent the consumer perspective, the passengers whom we help daily in their struggle to enforce their rights. Although the government portrayed the bill as improving passenger rights, this is clearly not the case. The bill seeks to remove or reduce rights that passengers already have. Imagine this committee being held captive in a metal tube with wings for 3 hours with scores of other people, with limited or no food or water, possibly clogged toilets, limited fresh air or heat, and absolutely no say in the matter. You would never impose it even on your worst enemies, would you? Yet, that is what the bill seeks to inflict upon Canadians. The bill seeks to double the length of time passengers may be confined to an aircraft without water or food from the current 90 minutes to 3 hours. This is not only unreasonable, but also inhumane. The current 90-minute rule is binding. An airline that breaks the rule can be fined, as we have seen it happen last year. For nearly 10 years, passengers and airlines were both content with the current 90-minute rule. Please keep the current 90-minute rule and amend the proposed paragraph 86.11(1)(f) to reflect 90 minutes. The bill also creates a new category of flight disruptions that are within the airline's control, but nevertheless, no compensation is owed to passengers. This category is to include mechanical malfunctions. This is a step backwards. Currently, under the Carriage by Air Act, which incorporates the Montreal Convention, an airline is liable to approximately $8,800 Canadian per passenger for delay in transportation. That's a uniform limit for all airlines. Canadian courts confirmed that maintenance issues do not relieve the airline from liability for delay, and European courts reached the same conclusion. In Europe, airlines are required to pay specific compensation for flight disruptions due to maintenance issues, and yet they have a healthy competitive market and profitable airlines. Please give Canadians the same protection as European passengers have. It has been tested and it works. Successful public interest complaints bridge the chasm between existing consumer protection laws and the airline's policies and practices that often blatantly disregard and misrepresent the law to the public. The Supreme Court of Canada recently confirmed that the law permits such complaints brought in the public interest. This judgment was handed down after the bill's third reading in the House of Commons and second reading in the Senate. Bill C-49 would reverse the Supreme Court of Canada's ruling by legislation. It would close the door to public interest advocacy and nail it shut by restricting the complaint to those who are adversely affected. The proposed restriction, introduced at the request of the airlines, targets air passenger advocacy groups and the efforts of the Council of Canadians with Disabilities. Please protect public interest advocacy and delete these measures aimed at silencing us from the bill. In closing, the bill as currently written would be an attack on and greatly erode the existing hard-fought for traveler rights. Please be a sober second thought and do not let this happen to Canadians. Please listen to the 100,000 emails of Canadians that were sent to you, all asking for the same thing, fairness. Please amend Bill C-49. Thank you.